Now, a trial court is a court of original jurisdiction, which means that it's the first court to consider an action. The trial court does the initial determination of the facts in the case. An appeals or appellate court only has appellate jurisdiction, so it reviews the lower court determination, but in general it defers to the lower court's finding of facts. The facts are supposed to be decided by the judge or the jury in the original case. The appellate case is limited to reviewing, affirming, or revising or modifying the decisions of the lower court based entirely on either the legal basis of the case or the conduct of the case by the judge. So an appellate court will only reverse or set aside a lower court's decision if it reflects a clear abuse of discretion by the trial court judge in ruling and administering the case. Otherwise, if the court simply disagrees with the way the judge or the jury decided a particular case, that's not a good enough basis to reverse, because it's up to the trial court to make the determinations on the fact. So if there's no abuse of discretion, then there's no basis for reversing the basic determination of the trial court. However, if the trial decision was based on an interpretation of law, the question of that interpretation of law can be decided by the appellate court as a de novo matter, meaning in the first instance. And so then the appellate court can clarify the area of law and then remand the case to the trial court for further proceedings, either a new trial or maybe a new determination based on this new area of law or this new clarification of the legal rules. Or, as I said, if it turns out that the appellate court found that the trial court abused its discretion, then again, it could be remanded back to the trial court to handle the case in a slightly different way and move forward. Now, the U.S. Supreme Court, as I said, has appellate jurisdiction with regard to those cases as it grants certiorari on, it chooses to address, and on those appellate cases, it functions like an appeals court, taking the facts as given below, but only ruling on the issue of law. There are a limited number of cases where the Supreme Court actually has original jurisdiction to hear the cases. So those are cases between two or more states, between the federal government and a state, cases involving officials of foreign countries, or a case involving a state against citizens of another state or country. And those are cases that are essentially tried for the first time in the U.S. Supreme Court, but those are relatively rare. Now I'm going to turn to the rules governing how you actually file and proceed in a lawsuit in a federal court using the federal rules of civil procedure. So first of all, a party who brings a lawsuit has to have what's called standing. And standing is the legal right to bring the suit. And standing's required under Article 3 of the U.S. Constitution, which, if you'll recall, is what sets up the judicial power of federal courts, and says courts have to decide actual cases and controversies. That means that if you happen to not like a law, you can't just bring a lawsuit saying, I don't like that law, please strike it down. You have to actually be harmed by that law, or you have to be in imminent danger of being harmed by that law. Similarly, if you see your neighbor doing something that you don't like and you want to bring a lawsuit about it, you can't bring that lawsuit unless you are being harmed in some way or about to be harmed. Otherwise, you don't have standing. That's sometimes referred to as the injury in fact requirement. Now, the person who brings a lawsuit in a civil case is called the plaintiff, and the person who is being sued is called the defendant. And the documents that the parties file in connection with their lawsuit are called pleadings. And the first pleading that generally gets filed is the complaint. The plaintiff files the complaint with the trial court, provides notice to the defendant that this lawsuit is moving forward, and then the defendant has to respond to the complaint by filing an answer. And in the answer, the defendant generally would admit or deny the various allegations in the complaint. Usually there are some basic background allegations that the defendant can safely admit, but there will always be some that the defendant will deny. Obviously, if there were none that the defendant would deny, then they would have settled the case and there would be no lawsuit. So there must be something that they disagree about. And those would be the issues that the defendant would deny. Now, the defendant can also raise what's called an affirmative defense. And an affirmative defense is a situation where the defendant says, yes, I did everything that you say I did, but I had a reason that the law permits for doing that thing. Or there is some other reason that the law recognizes that I should not be liable, even though I did the thing. And we will look in both the tort and the contracts context at certain affirmative defenses that the law recognizes in those areas. The defendant can also, in addition to affirmative defenses, file what are called counterclaims. Now, counterclaims are not just defenses to the original suit, but they are new claims that the defendant is bringing back against the plaintiff, almost like the defendant is bringing his or her or its own lawsuit back against the defendant, and those are counterclaims. And finally, the defendant can file a motion. And there are many different kinds of motions that you can do under the Federal Rules of Civil Procedure. Among the most common are motions to dismiss the case brought under Rule 12b of the Federal Rules, which allow the defendant to make a motion to dismiss because of lack of jurisdiction or lack of proper venue, and we'll talk a little bit about jurisdiction and venue in just a minute, or some failure to provide adequate notice, various ways in which you might say that the complaint is lacking or improper and therefore should be dismissed. You could also file what's called a 12b6 motion. And a 12b6 motion is a motion to dismiss based on the failure to state a claim upon which relief can be granted. And the idea here is the defendant is saying, even if everything you plaintiff said is correct in your complaint, it's not a cause of action. It's not against the law. It's not something that the law recognizes. And so a 12b6 motion would be appropriate. Now, in a 12b6 motion, you have to assume all of the plaintiff's facts are correct. Everything the plaintiff alleges is correct, and then the defendant is saying, nevertheless, I win. Now, if a court denies that 12b6 motion and the case moves forward, then obviously the defendant can say, actually, I disagree with your facts too. But at the 12b6 stage, you have to assume all the plaintiff's facts are true. Other pretrial motions include motions to strike certain matters as being inappropriate to be heard in a trial. Or, as I said, various other motions on the procedural aspects of the case. Now, after the case goes forward and there's been discovery and both parties can find out a little bit more about each other's case, there can be a motion for summary judgment. And either party can file a motion for summary judgment under Rule 56. And the idea there is if there's no genuine issue of material fact in dispute, if both parties basically agree on the facts, but as a matter of law, one party is entitled to prevail, then the motion for summary judgment would be granted. And it's essentially the judge saying, there's no reason to bring this case to a jury. I can decide this case based on the legal rules because there's no real issue of dispute about the facts of the case. We've talked already about the idea that there is a trial before a jury. in a trial court, each party presents evidence to either a judge or a jury. Most civil cases, though, are tried to a jury. Sometimes parties may opt for a judge, but most civil cases are tried before a jury, and it's known as a petit jury, a smaller jury, and that's as opposed to a grand jury, which we will talk about in a minute with regard to criminal cases. There are 12 members of a petit jury. The jury delivers a verdict deciding whether the defendant should be held liable for the complained of action or not. It's important to recognize that the plaintiff has the burden of proof in any civil case. So the plaintiff goes first. The plaintiff has to prove the basic case, what's called the prima facie case. And if the plaintiff cannot do that, then there will be a motion to dismiss. And the defendant will say, look, you are alleging all of these things. You haven't proved them. Therefore, I don't have to say anything. This case should be dismissed. That's a motion for dismissal, or sometimes called a motion for a directed verdict. If that motion is denied, then the defendant can go ahead and present evidence to defend against the plaintiff's claim, and then the jury would go and deliberate and reach a decision. In all civil cases, the plaintiff has to prove the case by what's called a preponderance of the evidence. You can think of that as 51%, more likely than not. Is it more likely than not that the plaintiff is correct, that the defendant did this bad thing that the plaintiff is saying that the defendant did? So it's a preponderance of the evidence. And if the jury fails to reach a decision one way or another, it's referred to as a hung jury, and the case will probably have to be retried. Now, every once in a while, even when a jury issues a decision, a verdict, a judge might grant a new trial or grant a judgment notwithstanding the verdict, which is known as a judgment JNOV, which says that the court believes that no reasonable jury, no rational trier of fact would have found as they did. That's obviously a very high standard, because in that situation, we know that the jury did in fact reach a particular decision. And so for a judge to say, despite that, the jury wasn't reasonable and I'm going to set aside the verdict, obviously is a big deal and is not done very often. As we discussed, the losing party at trial has the right to make an appeal. On appeal, whoever that losing party is, whether they're the plaintiff or the defendant, is now called the appellant, and the party on the other side is called the appellee or the respondent. Then the case will go forward to an appeals court. There we don't hear new witnesses and new findings of fact, as we discussed. It's only a legal discussion, and so there will be oral arguments with the judges and the lawyers, but no witnesses and so forth. And then, as we discussed, you could go to the U.S. Supreme Court, but that doesn't happen very often. Assuming all of the appeals are over and we're done, then that judgment becomes final and cannot be challenged in another proceeding. It's known as res judicata, or what's often referred to as claim preclusion. It means you cannot keep relitigating the same claim over and over and over. You have to live with the decision, even if you don't like it, and we're done and we can move on. Now, all of that is in civil cases. Criminal trials, as I said, are brought by the government, so there is no plaintiff. There is a prosecution being brought by the government, whether it's the state or the federal government. And before going to trial, the prosecution presents an indictment, which is a written set of charges against the defendant, and they present that to a grand jury, which is a group of between 16 to 23 jurors. And they only hear the prosecution side of the case, and they only determine not whether the defendant is guilty, but whether there is enough evidence based on the indictment to justify having a trial. And so that's all a grand jury does. And the Fifth Amendment of the Constitution actually requires that all criminal cases be presented to a grand jury. And the idea is that it's a check on prosecutorial misconduct to make sure that prosecutors don't simply bring cases against anyone they have some sort of a bias against or an animus against. They actually have to have enough evidence even to go to trial in the first place. And grand juries can sometimes subpoena witnesses and documents. They can sit for a long time to determine whether the prosecution has enough material to at least bring the case to trial. The Constitution also grants additional rights to a criminal defendant, such as the right to a speedy trial, the right to a trial by jury for serious offenses, the right to counsel, and additionally, for a criminal defendant to be found guilty, the government has to prove its case beyond a reasonable doubt. Remember, we talked about in civil cases, it was just a preponderance of the evidence, 51%, more likely than not. That's not the case in a criminal trial. In a criminal trial, it has to be beyond a reasonable doubt, which is a much higher standard. The idea, obviously, being that the government really has to jump through a lot of hoops and really needs to be able to prove its case if it's going to be able to deny someone their liberty and send them to prison potentially or levy criminal fines against them. Now, if the defendant is found guilty, she can challenge her conviction by making appeals, the same way you can in a civil case. And once you appeal initially, you may also be eligible in the criminal context to file what's called a writ of habeas corpus. And that's a writ to a federal court saying, I need a new trial to determine if I am being unlawfully deprived of my liberty. And so that's only if you're in custody, you're saying, I'm being held in violation of the law. So habeas is used as a challenge basically after all of your direct appeals are done.